Today on Because Liberty, we have horn honking in Washington State, the law and morality, and the Nuremberg defense. So welcome to Because Liberty. I'm your host, Curtis Hart. Today we're going to be talking about a few different subjects. One is a local subject here in Cowlitz County. We had the teacher strike here in town, and there was some people driving past the teacher strike, honking their horns, and the Longview Police Department decided to pull some people over and give them warning tickets. So we will just jump right into that.
From the Punisher Squad just showed up at our door. Curtis Hart is his name.
Not because you're Jason fucking Freeman.
Curtis Hart is his name.
Not because you're Jason fucking Freeman.
I'm not gonna suck your dick.
Oh, that's too bad, because you would fucking enjoy it, I'm sure.
So we had the Longview Police Department pull some people over. No matter how you feel about the teacher strike here in town, I'm not getting into the whole subject of the teacher strike. That could be a whole episode in and of itself. But the thing that I'm going to be touching on is the Longview Police Department pulling people over that were honking their horn in support of the teachers union. So I'll just go ahead and read what they had to say about that on their Longview Police Department's Facebook page. So, motor vehicle horns. When negotiations between labor and management fail to result in an agreement, the disagreement may spread to the streets in the form of picketing or other bargaining tactics. Some form of police involvement may become necessary. Clear violations of criminal laws occasionally take place during strikes, but most of the statutes that are broken are civil in nature. Since active police intervention may benefit one dispute to the detriment of the other, department policy discourages arrest except when necessary to protect life and property, to preserve the peace, or to protect the opportunity for all persons to exercise their lawful rights when they wish to do so. The First Amendment prohibits use of criminal sanctions to interfere with free speech and the right to peacefully assemble to redress of grievances. It's funny that they note that, but yet they decide to stop people from doing that. It follows that police cannot interfere with peaceful picketing, although disorderly picketing and conduct obstructing or reasonably interfering with free ingress and egress is subject to enforcement action. Today, our officers stopped a couple of vehicles for nonstop honking of their horns for approximately 115 yards through a busy area. This was a safety issue, and each driver was given a warning. No tickets that we are aware of have been issued. It's funny that they wouldn't know whether or not that there were tickets issued. That just totally sounds like that they're leaving themselves open to not telling people that they actually gave somebody tickets for stuff. I don't know for sure that they did or not. They're not even for sure that they did or not. So that should be something that somebody should probably do a records request for to find out whether or not they actually did that. So here's the RCW that they quoted when they pull people over out there. Every motor vehicle, when operated upon a highway, shall be equipped with a horn in good working order, blah, 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 blah. Let's get down to the part that matters here. The driver of a motor vehicle shall, when reasonably necessary to ensure safe operation, give audible warning with his or her horn, but shall not otherwise use such horn when upon a highway. Now, they stopped people that were out on Ocean Beach Highway. They happened to stop somebody that was in support of the teachers union strike, and she claims that she wasn't honking her horn for 115 feet. There's no really way to tell who's telling the truth there. But what does matter is that the Longview Police Department came out and showed people the Longview Municipal Code, which is LMC 9.22.0404. Disorderly conduct states the operation of a motor vehicle within the city in a manner that disturbs the public peace and tranquility, whether by excessive speed, excessive noise, or by other operation manifesting disregard for reasonable safety precautions, is a violation of the law. And the important part here to note is the excessive noise. Now, what is excessive? Who decides what is excessive? Obviously it's going to be the police officer that is pulling the people over. It's very vague. It doesn't tell you exactly what is excessive. They said a couple of toots of the horn is okay, but laying on the horn for long periods of time is not okay. Now, that's just amazing because as far as I'm concerned, it's a First Amendment violation to stop people from doing that. And, I don't usually, the way I think doesn't usually line up with how the courts think. Doesn't usually line up with how the state thinks. But in this certain instance, the Washington State Supreme Court actually agrees with me that it is a violation of people's First Amendment rights to blast your horn basically for as long as you want, especially when you have a statute here that is extremely vague, just saying excessive noise. Like, what is excessive? Who decides what is excessive? So I'm going to go ahead and touch on the Washington State Supreme Court case that I found that has to do with this. This is the state of Washington versus Helen Immelt. I'm not positive that I'm actually saying her name correctly, but this was back in October 27th, 2011 was when it was decided. So Helen Immelt sounded a car horn at length in front of a neighbor's house in the early morning hours. She was arrested for violating a Snohomish County noise ordinance that includes amongst its prohibited noise disturbances horn honking for a purpose other than public safety or originating from an officially sanctioned parade or other public event. She challenges the horn ordinance as overbroad and in violation of free speech protections. We agree that the ordinance is overbroad and reverse Immelt's conviction. So wait till you see what this lady did compared to what the people were doing that were honking the horn in support of the teachers. Now, what she did isn't even something that I would do, because I would fully expect to get arrested for this. But apparently, it's okay, according to the Washington State Supreme Court, because the law was too vague. It was overbroad. It's excessive. Who's to say what's excessive? Well, the Snohomish County Code bans sounds that is a public disturbance noise. Snohomish County Code, blah, blah, blah. The code defines public disturbance noise to include, amongst other things, sounding of vehicle horns for purposes other than public safety. A violation of whatever that code is an infraction unless two violations of the ordinance are committed within a 24-hour period, in which case a second violation is criminalized as a misdemeanor. Although the facts of this case are not critical in overbreadth challenge, see Seattle v. Webster, we offer them by way of background. Listen to this. Listen to what this lady did. Immelt lived in a cul-de-sac neighborhood governed by restrictive covenants. On May 12, 2006, Immelt received a letter from the Homeowners Association indicating that she had violated a covenant prohibiting residents from keeping chickens. Immelt learned the complaint was lodged by her neighbor, Mr. that person's name. Big, huge German-sounding name. A little before 6 a.m. the next day, Immelt borrowed a friend's car and repeatedly honked the car's horn in front of Vordenbergen's house for approximately 5 to 10 minutes. She laid on the horn for 5 to 10 minutes before 6 a.m. Okay? Her actions awakened several neighbors. Vordenberger called police. Sergeant David Cassidy of Snohomish County Sheriff's Office arrived around 7 a.m. and spoke with Immelt about the noise complaint. He then went to Vordenberger's house to take statement. While Sergeant Casey was at Vordenbergen's house or residence, Immelt drove past and made 3 long car horn blasts. Sergeant Casey followed his patrol car, stopped Immelt, and arrested her. So he came up, basically probably told her, like, yo, you can't be doing this, blah, blah, blah. Can't be laying on your horn at 6 a.m. for 5 to 10 minutes. Imagine that. And her response was to drive past the neighbor's house while the officer was out there speaking to them and lay on the horn 3 more times. Snohomish County charged Immelt by amended complaint with violation of local noise ordinance, barring the sounding of a horn for purposes other than public safety. A district court jury convicted Immelt, and her conviction was affirmed by both the review administrative law judge and the Court of Appeals. State v. Immelt 150. I'm not going to say the whole name of the case. Immelt petitioned this court for review, raising a variety of claims, including claims that the horn ordinance violated her state and federal constitutional rights. We granted review, and then they list the name of the case. Our Article 1, Section 5 analysis of overbreadth follows the analysis under the First Amendment. Bradford v. N. Okay. It was a library district. Okay. A law is overbroad if it sweeps within its prohibitions a substantial amount of constitutionally protected conduct. City of Tacoma v. Levine. A statute or ordinance will be overturned only if the court is unable to place a sufficiently limiting construction on a standardless sweep of legislation. Immelt claims the horn ordinance is overbroad because it sweeps into its prohibitions constitutionally protected speech. Yes, the court has ruled that honking your horn is speech. So for those of the people out there on Facebook that are like, how is honking your horn free speech? Well, it just is. You know, free speech doesn't have to be speech. Free speech can be things like going out and being naked, as long as it is in protest of something. It is holding a sign. It is apparently honking your horn. It could be burning the flag. Protected free speech is basically any way that you decide that you're going to convey a message or do something in protest of something else that is considered, as far as the state is concerned, free speech. So thus we must determine whether the horn ordinance actually implicates free speech. Some burden on speech must exist before the protection of the First Amendment or Article 1, Section 5 may be invoked. See State v. Hallstein, the rest of that case number. This question does not require us to determine whether Immelt's particular actions amounted to protected speech. An overbreadth challenge allows attacks on overly broad statutes with no requirements that the person making the attack demonstrate that his own conduct could not be regulated by the statute drawn with the requisite narrow specificity. Broderick v. Oklahoma. Okay, and they quoted another case there. The question is whether the horn ordinance impermissibly burdens protected expression. Conduct such as horn honking may rise to the level of speech when the actor intends to communicate a message and the message can be understood in context. And then they go and they cite a couple of other cases. See First Covenant Church of Seattle v. City of Seattle. And they quoted Texas v. Johnson. And for those that don't know, Texas v. Johnson is the case that allows people to burn the flag in protest. There's a lot of people that think that the U.S. flag code clearly states that you cannot do that such a thing, that it makes it against the law. And that was true until 1989, when Texas v. Johnson was finally decided by the United States Supreme Court, and they decided that burning the flag was in fact free speech. I'd like to just throw out there, I've never burned a flag. I'm not planning on burning a flag. I wouldn't burn a flag more than likely, but it is actually protected free speech. So here I'm going to show you the post on Facebook that made me decide to make this video. Horn honking is illegal when it's not being used for emergency purposes, because they were quoting what the Longview Police Department said. I said, so what? The law is no measuring stick for morality. Slavery was legal. The Holocaust was legal. So what? Well, every action has a consequence. You do something illegal, and your consequence is not going to be a good one. The police are doing their job. They aren't in the wrong. Well, in this case, police, according to the state of Washington, weren't doing their job. They were trampling on somebody's First Amendment rights, because honking your horn is in fact free speech according to the Washington State Supreme Court, as I have just demonstrated by showing you that Supreme Court case, the Washington State Supreme Court case. So for those of you that are so concerned with the law, it's the law. There you go. That's the law of Washington State. And as we all know, unfortunately, as far as I'm concerned, when the state decides to decide something like this, the state's law oversees the local municipal codes, just like federal law trumps state law. In most cases, I mean, we get to smoke marijuana here in Washington State if you so choose to, and you know that's not in line with federal code, but in most cases, when the feds decide something that the states don't like, they just, I guess, throw out the 10th Amendment of the Constitution, and they get to decide that. In this case, the state decided that honking your horn was free speech, and so they overturned the lady's conviction, meaning that the local ordinance really doesn't count because it was overbroad. It was overbroad because it didn't specifically say what is illegal. So there you go. Excessive. What is excessive? Who decides what is excessive? Well, for those people out there that were honking your horn and got stopped by the police, if you would have taken the ticket and appealed it and cited this case, most likely you would have had it thrown out, and the city of Longview would have to change their overbroad municipal code. So what I'm going to do now is I'm going to touch on the police are just doing their job. Now, what that is right there is literally called the Nuremberg defense. And I'm going to show you a couple of people here that the Nuremberg defense didn't actually work out for. They These guys that I'm going to show you right here, they tried saying we were just doing their job, and the Nuremberg trials decided to hang them, except for Hermann Göring here on the left, president of the Reichstag. He killed himself before they got to hang him. But the two guys here on the right, William Kettle and Alfred Jodl, they literally tried saying that they weren't guilty of war crimes because they were just doing their job. And it's literally called the Nuremberg defense. When you're just trying to say, I was just doing my job, I was just following orders. No, you are supposed to take into account what is right and wrong. You don't get to use that as an excuse. I'm just throwing up this meme here for, a little. It didn't happen because of the actions of one man. It happened because of people who were just doing their jobs. And that's what happens when people are just doing their jobs and they just blindly follow the orders of the state and the orders of the leaders and rulers. You get things like people trampling on your natural rights. So here we have all the people in the Nuremberg trials. For those that don't know, the Nuremberg trials was when the Allied forces tried 24 of the top Nazi officials between November 20th, 1945 and October 1st, 1946. 11 of them got hanged, including Keitel and Jodl. Like I said, the other one, he decided to just go ahead and off himself before his sentence was carried out. He followed in the footsteps of the rest of the extreme higher-ups in the Nazi Party. So that's what happens when you try to claim that you are just following orders. You get the Nuremberg defense, and it doesn't work. It's not something that works. So when people are claiming that you should just follow the law, here's what you have when people are just following the law and making decisions based off just the law instead of morality, and why the law doesn't equal morality. Slavery was legal. Okay? Slavery was legal in America for quite a long time. It was definitely not the moral choice. Helping people on the Underground Railroad, that was an illegal thing to do. Not letting people of color use the same restrooms, the same water fountains, sit at the same lunch tables, use the same restaurants, the same theaters, that was legal. Definitely not the moral choice. Hiding Jews in World War II, that was illegal. It got you summarily executed. Hiding Anne Frank, that got them summarily executed. Well, not summarily. She was sent to a concentration camp. Simply being a Jew in Vienna. This is the guy on the bottom right. He was the last Jew in Vienna. And as you can see, the state doing something that was completely illegal in the country where they're at because they were the ones in charge, executing him. Not the moral choice, but they were following the law. They were just following orders. And so that's basically all I'm going to leave you with right now is think for yourself. Don't just do something because the state tells you to do it. You should have your own set of moral values. You should be able to think for yourself and decide for yourself whether or not you're going to do something. When I have a choice in front of me, I never think, is this legal? I always think, is this right? Is this right for me? And if it's not, I don't do that thing. If it is, I do. I don't really care if the law says not to do it or not. It makes no difference to me whatsoever. And if I decide to do something that's against the law, I look over my shoulder, make sure that the state's not standing over there, like make sure that there's not some person out there that's gonna say, oh, well, you should just follow the law and narc me out. But I very much decide for myself whether or not I'm going to do a thing. And that's about where I'm going to leave you, folks. Have a good day.
He walked out of the store. He said, "Try not to suck any dicks on your way out." And look at this guy. Listen. This is what he does. This is what he does.
Listen.
What? And see, this is his MO. He tries to get people riled up and then get them on camera.
I did get you riled up.